Hello everyone, I am Dr. Sharad Kumar, Assistant Professor, Department of Wildlife Sciences, Aligarh Muslim University, Aligarh. India's forests are not just carbon sinks, they are the cradle of biodiversity, cultural integrity, and economic stability. Encompassed within these green expanses lies the heartbeat of the nation, and safeguarding them is the key to ensure environmental conservation and well being of humans. The Forest Conservation Act of 1980 stands as a testament to India's commitment to preserving its green heritage. It is a unique piece of legislation and a regulatory mechanism that reflects the collective will of the nation to protect its rich biodiversity and natural heritage, and that permit only unavoidable use of forest land for various development purposes. In this lecture, I shall be exploring into the intricacies of this landmark legislation, elucidate its pivotal role in forest conservation and its impact on India's environment and communities. Importance of forest. Forests have ecological, economic, and cultural importance. Forests are dynamic ecosystems that play a vital role in maintaining ecological balance. They serve as a sanctuary for an array of flora and fauna, facilitating biodiversity conservation and acting as natural buffer against climate change and global warming by regulating local and global weather patterns. They also play a very important role in regulating various geochemical cycles. The green expanses of forested areas are providing resources for numerous economic activities. Millions of people depend on forest resources for their livelihood, from timber and fodder to non timber products like fruits, medicinal herb, and honey. Forests also encourage tourism activities and contributing to the nation's socio-economic development. Ancient civilizations have thrived in the lap of these forests, and various communities today still have deep cultural and spiritual connection with the forest. Festivities, folklore, and daily rituals are intricately linked with existence and reverence of forest landscapes. So, the conservation of forests is essential for the ecological, economic, and cultural stability of India. Overview of the Act. Genesis. The Forest Conservation Act was enacted by the Government of India with an imperative to curb deforestation and to regulate land use. It is instituted amidst growing environmental concerns. It triggers a more centralized approach to forest conservation. Objective. This act's primary motive is to preserve forest cover by strictly limiting forest land diversion for non-forest purposes. It strives to maintain ecological balance and protect forest as a natural resource. Scope. The Act expands across all state and union territories, emphasizing that conservation is not just a regional but a national concern. It applies to all forest land, including those in private hands. Let's learn about the key provisions of the Act. Section 1 of the Act states that this Act may be called the Forest Conservation Act of 1980 and it extends to the whole of India. It shall be considered to have come into force on the 25th October 1980. Section 2 of the Act is about the restriction on the state government for dereservation of forest or use of forest land for non-forest purpose. It prohibits the state government except prior permission from central government for issuing orders for dereservation and diversion of forest lands. It also defines the non-forest purposes. According to the Act, non-forest purpose means the breaking or clearing of any forest land or portion thereof for the cultivation of tea, coffee, spices, rubber, palms, oil-bearing plants, horticulture crops of medicinal plant, and any purpose other than reforestation, such, such as construction of checkposts, etc. Section 3 of the Act deals with Constitution of Advisory Committee. It empowers the central government to constitute a committee to advise the government with regard to the grant of approval for the purpose which is prohibited in Section 2 of this Act or any other matter connected with the conservation of forest which may be referred to it by the central government. Section 3A deals with penalty for contravention of the provision of this Act. It states that whoever contravenes or abets the contravention of any of the provision of Section 2 shall be punishable with simple imprisonment for a period which may extend to 15 days. Section 3B deals with cases in which the offences are made by authorities or government department. In such cases, it says that head of the department or every person who at the time of the offence was committed shall be considered guilty, provided that nothing shall render the head of the department or any person liable to any punishment if he or she proves that the offence was committed without his knowledge or that he or she exercised all due diligence to prevent the commission of such offences. Section 4 of the Act deals with power to make rules. It states that the central government may make rules for carrying out the provision of this Act. So, central government can make the rules for protection and conservation of forest, but this power is not vested with the state governments. The rules made by the central government shall be laid before the parliament as soon as possible, or you can say both the houses of the parliament as soon as possible. Section 5 of the Act deals with repealing and saving, and it states that Forest Conservation Ordinance 1980 is hereby replaced, and notwithstanding such repeal, anything done or any action taken under the provision of the said ordinance shall be deemed to have been done or taken under the corresponding provision of this Act. Forest Conservation Rule 2003. So in 2003, in exercise of the powers conferred by the subsection 1 of the section 4 of the Forest Conservation Act of 1980, the central government hereby make the rules to implement the provision of this Act and to ensure the conservation of the forest in the India. These rules are about the composition of the committee constituted under the section 3 of the Act. The section 4 of these rules defines terms of appointment of non-official members in the committee, and section 5 of the rules provide for the conduct of business of the committee. These committees look into the various issues prescribed by the central government or forwarded by the central government to the committees. Proposals for the use of forest land for non-forest purposes shall be submitted to the central government using the appropriate forms attached to these rules, and these forms are prepared by the central government under the Forest Conservation Rules 2003. The central government shall refer every proposal to the committee for the advice. The committee shall have due regard to all or any of the matters specified in Sub-Rule 1 when tendering advice on the proposal. The Water Prevention and Control of Pollution Act 1974. Another important resource which is essential for life on earth is water, but it is continuously degrading and depleting due to various anthropogenic activities. So, to prevent the degradation of water resources of India and to ensure the availability of safe water for future generation, our parliament enacted the Water Prevention and Control of Pollution Act of 1974. This is an important legislation in India aimed at preventing and controlling water pollution. Let's have a comprehensive knowledge of the Act. It is an act to provide for the prevention and control of water pollution and the maintaining or restoring of wholesomeness of water for the establishment with a view to carrying out the purposes aforesaid of boards for the prevention and control of water pollution, for conferring on and assigning to such boards powers and functions relating thereto and for matters connected therewith. So the chapter 1 is preliminary and deals with short title, application and commencement and definition of important terms used in the Act. This Act may be called Water Prevention and Control of Pollution Act 1974. Definition of the important terms are provided in the section 2 of the chapter 1. For example, Act defines pollution as contamination of water or such alteration of the physical, chemical or biological properties of water or such discharge of any sewage or trade effluent or any other liquid, gaseous or solid substances into water, whether directly or indirectly, as may or is likely to create a nuisance or render such water harmful or injurious to public health or safety or to domestic, commercial, industrial, agricultural or other legitimate uses or to the life and health of animals or plants or of aquatic organism. So the Act adopts a very broad definition of the pollution and include the various things which cause the water pollution. This chapter provides for the constitution of the central board and the state boards, terms and conditions of service of members of boards, meetings of the boards, and the constitution of the committee, amongst other. The section 3 of this chapter states that central government shall constitute a central board to be called Central Pollution Control Board to exercise the power conferred on and perform the functions assigned to that board under this Act. It also provides information about the selection and procedure of selection of members of the boards. Section 4 of this chapter deals with the constitution of state board and said that state government has the power to assign or set up a state board named as State Pollution Control Board. Section 5 of this chapter deals with terms and conditions of service of the members and state that a member of board shall hold office for a term of 3 years from the date of his nomination. Section 8 of this chapter deals with meetings of boards and it said that the board will meet at least once every 3 months and observe rules of procedure in regard to the transaction of business at its meeting. Section 9 of this chapter deals with constitution of the committees and it permits the central or the state boards to constitute a committee of members either from the existing members or totally new members who do not have any connection with the company for the performance of the duties. Section 10 of this chapter provides for temporary association of person with board for particular purpose, and it permits a board to associate itself with person whose assistance or advice it may desire to obtain in performing any of its function under this act. The chapter 3 provides for the constitution of the joint boards and the composition of the joint boards and direction by the state government and central government to these joint boards. Section 3:13 deals with constitution of joint boards and state board and state that an agreement may be entered into by the state government of one state with the state government of another state to set up a joint board. Section 14 provides details about the composition of joint boards, while Section 15 empowers central government and state government to give direction to various boards constituted under this act and committees on issues related with prevention of water pollution. Chapter 4 provides for the powers and functions of the board. Section 16 states that main function of the central board shall be to promote cleanliness of streams and wells in different states. Central board may perform all or any of the following functions: advise the central government on any matter connecting the prevention and control of water pollution, coordinate the activities of the state boards and resolve dispute among them if there is any dispute. It is also responsible to organize thorough mass media and comprehensive programs regarding the prevention and control of water pollution and creating awareness among the various sections of the society. It is also responsible to provide technical assistance and guidance to the state boards of the different states. Functions of the state boards. Functions of state boards shall be to plan a comprehensive program for preventing and controlling the pollution of wells and streams in the state and to secure its execution, to advise the state government on matters relating to prevention and controlling water pollution. It is also responsible for collaborating with the central board to train persons employed or to be employed in preventing and controlling water pollution. The state board are also responsible to lay down and modify the effluent standard of sewage and trade effluent and for the quality of receiving water resulting from the discharge of effluents and to classify water of the state. It is also responsible to evolve method of utilizing sewage and suitable trade effluent in agriculture fields. Chapter 5 provides for the power of the state government to restrict the application, power to obtain information, power to take samples of effluents and procedures to be followed in connection, and prohibit on use of streams or well for disposal of the polluting matter amongst others. Section 19 of this chapter gives power to state government to restrict the application of the act to certain areas, and the state board has the power to limit the territorial jurisdiction of any other order passed by it in matters relating to the prevention and control of water pollution. Under Section 20, the State Board has the power to inspect any land, conduct surveys, or goes in an area for controlling or preventing water pollution. Section 21 empowers the State Board or any employee on its behalf to analyze any stream or well for the purpose of preventing and controlling water purpose analysis of sample taken. The Act also empowers officers of the boards to enter the premises for the inspection of any violation of the Act or any case of water pollution. Section 24 deals with prohibition on the use of streams or wells for disposal of polluting waters and state that no person shall knowingly cause or permit any poisonous, noxious, or polluting matter to enter into any stream or well or sewer or on land. Section 25 of this chapter states that no person is allowed to set up an industry or start a new operation or process for any treatment of sewage without prior approval of the State Board. Section 27 empowers the State Board not to grant any notice for setting up an industry or continuation of an existing operation. The Act also empowers the boards to take immediate action if it appears to the State Board that any poisonous, noxious, or polluting matter has entered into any stream, well, or land. The chapter 6 deals with contribution by central government to the central boards, contribution of funds by state government to the state boards, budgets, audit of expenditure, and preparation of annual reports and submission of annual report to Parliament and state legislatures. The chapter 7 deals with penalties and procedure to be established the offense. The section 41 of chapter 7 states that failure to comply with direction under subsection 2 or subsection 3 of section 20 is punishable with imprisonment for a term which may extend to 3 months or with fine which may extend to 10,000 rupees or with both, and in case the failure continue with an additional fine which may extend to 5,000 rupees for every day during which such failures continue after the conviction for the first such failure. Section 47 deals with offenses by companies, and it states that where an offense has been committed by a company, every person who at the time of the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against any punished accordingly. Section 48 deals with offenses by government department and states that where an offense has been committed by any department of government, the head of the department shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. While failure to comply with orders issued under Clause C of subsection 1 of this section 32 or direction issued under the subsection 2 of the section 33 or section 33A is punishable with imprisonment for a term which shall not be less than 1 year and 6 months, but which may extend to 6 years, and with fine, and in case the failure continue with an additional fine which may extend to 5,000 rupees for every day during which such failures continue after the conviction for the first such failure. If failures referred to in subsection 2 continue beyond a period of 1 year after the date of conviction, be punishable with imprisonment for a term which shall not be less than 2 years, but which may extend to 7 years and with fine. Chapter 8 deals with varied matters. Section 51 of the Chapter 8 states that central government may establish central water laboratory or specify any laboratory or institute as a central water laboratory to carry out the function entrusted to the central water laboratory. Section 52 of this chapter said that state government may establish a state water laboratory or specify any laboratory or institute as a state water laboratory to carry out the function entrusted to the state water laboratory. Section 53 states that central government and state government may appoint such persons as it thinks fit and having the prescribed qualification to be government analysts for the purpose of analysis of samples of water or of sewage or trade effluent sent for analysis to any laboratory established or specified. Section 54 states that any document purporting to be a report signed by the government analyst or as the case may be a board analyst may be used as evidence of the fact stated therein any proceeding under this act. Section 58 states that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which an appellate authority constituted under this act is empowered. Section 59 states that no suit or other legal proceedings shall be lie against the government or any officer of government or any member of officer of a board in respect of anything which is in good faith done or intended to be done in pursuance of this act or the rules made thereunder. Section 63 empowers central government for the constitution of the central board to make rules in respect of the specified matters such as terms and conditions of service of the members, intervals and the time of the meetings and places at which meeting of the central board or any committee thereof constituted under this act shall be held, and the procedure to be followed at such meetings, conditions subject to which a person may be appointed as a consultating engineer to the central board, powers and duties to be exercised and performed by the chairman and the member secretary of the central board, etc. Section 64 states that state government may simultaneously with the constitution of the state boards make rules to carry out the purpose of this act in respect of matters not falling under the purview of the section 63, which is under the central government. Let's join hands to control and prevent the water pollution and ensure availability of clean and safe water to everyone. Thank you.